Welcome everybody to our last instalment of our property development series for the year, which, as some of you know, is a series of seminars we've been putting on with the team. I head up the commercial disputes team here, as well as Melissa Potter's team. Melissa's in the audience somewhere at the back there, the property team and land and environment. So we really enjoy working together to put these events on. So this one is tips and traps for developers in a changing property market, and we have two great speakers lined up for you tonight. And it isn't going to be a Q&A session. We're going to have Tony and Sharon saying a few words about different aspects of the topic, and then they'll sit back down in their chairs, and then there'll be an opportunity for everyone to ask questions after that. So, without taking up any more time, I'll just introduce our speakers and then over to Sharon. So, our first speaker tonight is Sharon Levy, who's a Senior Associate in the Commercial Disputes team. She acts for clients in varied industries and markets, and that has enabled her to develop tailored strategies in conjunction with her clients, which are pragmatic, effective and commercial. With extensive experience and knowledge in general commercial disputes, Sharon also has a particular expertise in building and construction and strata disputes. Through working in boutique and mid-tier firms for over 15 years, she has experience acting for a diverse range of clients, including builders, developers, subcontractors, owners, corporations, high net worth individuals and councils. Sharon regularly appears in the district and Supreme Courts, as well as NCAP, and prides herself on providing clients with exceptional results. In addition to all of that, Sharon is also the chair of a not-for-profit organisation which she set up, and in that role it gives her valuable training, insight and experience into the duties and obligations which govern many of her clients. So I'll hand over to Sharon now.
Thank you. Okay. Thank you, Gavin. Let's see if we can... Got a lot to talk about tonight, and I'm conscious of the time and the good food that's being prepared for us, so I'm just going to move straight on into it. First of all, I will speak the process of a contract for sale and an option agreement and the critical steps involved in that. We'll then move on to the booming market, which we've just come out of, and the practical effect and some new legislation which was just implemented as a result of the booming market. We'll then move on to a judgment that just came down last month with respect to that new legislation, and then talk about the practical effect of the falling market, which we're currently in, and then lessons, takeaways and sample clauses before we move on to the strata renewal process, which is fairly topical at the minute. Tony will then talk about the characteristics of a booming and a falling market before he moves on to the variables in property development, so the practical side of property development, including site acquisition, product, competition matrix, buyer profiling and then politics. Getting into it then, the process of a sale and option agreement. We're going to refer to this flowchart and this process fairly regularly in the next little while, so now is the time to concentrate before you switch off. First of all, a call option deed is prepared. Generally that'll annex a contract for sale. The landowner and the developer generally will execute the call option deed. The developer pays the call option fee and the call option deed becomes binding. Generally then, the parties might engage in the strata renewal process, which we'll talk about in a little while, and the developer might apply for a development consent with their local council. Moving down to here then, following that process, the developer has two options, either to exercise or not exercise the option, I beg your pardon, and if they choose not to exercise the option, the call option period will expire and there are no further obligations by either party under the deed. Alternatively, come over to this side, the developer might choose to exercise the option and they do so within the call option period. The parties will exercise the contract for sale, the developer will pay the deposit, and that is less any call option fee which may have already been paid, and the contract for sale will then come into effect. The sale will then complete on the completion date just as a normal conveyance set out in the contract. And then moving down to here, the developer may then choose to obtain a development consent if they haven't already, And then they may choose to sell the product off the plan, so they may have some units they may seek to sell off the plan. Looking first at the booming market and the practical effect on option agreements. So we're looking at this process here, whether they're going to choose to exercise the option or not. So a booming market, what are the practical effects? Generally speaking, the signing of an option agreement in a booming market will mean between a vendor landowner and a purchaser developer will generally mean a guaranteed sale for a landowner. They can sign that option agreement and head on off to crack some champagne. A purchaser developer under an option agreement will fulfil their obligations under the option and comply with the timetables that may have been set out in the option agreement. They're generally happy to exercise the option agreement since the value of the property between the signing of the option agreement and the exercise of the option has increased. Going back just quickly to our flowchart, and we're at this point here. At this point here. Let's go all the way down. We assume that they've exercised the option. They choose to obtain their development consent. They want to sell off the plan. The developer now becomes the vendor in an off-the-plan contract. Now, an off-the-plan contract is a contract for the sale of a lot that does not have a separate title at the time the contract's been entered into. They're used by developers when they want to pre-sell vacant land or strata lots before the necessary building and contract works have been finalised. Generally, it's used as a tool to increase their cash flow before they start building. A sunset clause is a provision in an off-the-plan contract that will provide for that a contract can be rescinded if the lot has not been created before the sunset date. Normally, these kinds of contracts will require the vendor developer to use what's known as their reasonable or best endeavours to create the lot by the sunset date. If the lot hasn't been created by the sunset date, the contract will normally provide that the developer has the right to rescind the contract. Now, in a booming market, some vendor developers may seek to take advantage of the sunset clause and seek to terminate off-the-plan contracts to take advantage of the rising prices. They may deliberately try to delay the creation of the lot, so they've got a right to rescind the contract later on. To prevent that exact thing from happening, changes to the Conveyancing Act were introduced in late 2015, and they require a vendor developer to first seek permission from a purchaser before they can rescind the contract. If the purchaser chooses not to give that consent, the developer then needs to make an application to the court for the relevant orders before they can rescind that contract. Now, that exact thing happened just last month when the Supreme Court handed down a judgment. A developer had taken a group of buyers of a new building in Surrey Hills to court to argue that it was entitled to rescind their contracts because problems with the development had pushed the completion of the development beyond the sunset date. On the flip side, the buyers argued that the developer was merely trying to take advantage of the rising market to cancel their contracts so that he could resell the apartments for a higher price in the rising market. Justice Stark of the Supreme Court agreed with the buyers and said that the developer had not acted justly or equitably in trying to rescind the contracts. He dismissed the developer's bid to tear up the contracts, he made the developer complete the sales, and on top of all of that, he awarded costs and kicked the development out of the apartment complex. Going back again to the flowchart, and we are back at this point, at just here, when a developer may seek to obtain a development consent. So in that context then, we're back to looking at option agreements and before the developer has chosen to exercise the option agreement. What happens in the falling market? This is where we're in now, and Tony will speak about more of that in a moment when he gets up and speaks about the practical effects from his point of view. But generally, the value of property in a falling market is higher today than it's going to be tomorrow. So while the developer is off getting his development consent and trying to work out whether or not he's going to exercise that option agreement, the property value is dropping while a council determines that development application. On that basis, there might be a potential increase in Class 1 Land and Environment Court appeals, since as soon as the 42-day deemed refusal period has lapsed, a developer's going to head off to court, file their Class 1 application and try to get that development consent as opposed to waiting for their negotiations with council to be finalised. It means that some purchaser developers are not going to exercise their options. A developer entering into an option agreement and then obtaining their development consent may still walk away from that option on the basis that by the time they get their development consent, the numbers don't stack up anymore. It's not feasible for them to exercise their option under the deed. Another factor playing a part in this is the fact that finance for developments is a lot harder to get in a falling market. On top of all of that, there may be a potential increase in objections to strata renewals. Before we get to the strata renewal process, let's talk about some takeaways from the differences in a falling and a booming market. The big takeaway needs to be for developers in this instance is that special conditions of contracts and option agreements are vital. So at the time of negotiating that option agreement, a developer needs to think about clauses such as the best endeavours clause. Who is obligated to do what? What does the best endeavour clause mean? And are there any milestone events that the developer needs to complete in order to meet the best endeavours clause? So for example, a developer can't cause works to be delayed through the non-payment of contractors or otherwise. Conditions of a development consent need to be pursued diligently. They can't sit on their hands and at the end of the sunset date say, well, I did my best, when they've been sitting around and not pursuing the development consent. Payments to authorities to enable works to proceed or the project to proceed generally to registration also should be made promptly. The other important issue to consider when entering into an option agreement is the importance of an option fee. That really increases in the event of a falling market when more and more developers are not going to exercise that option agreement. Looking then at some example clauses, so you look first of all at the reasonable endeavour clause. So the vendor must use reasonable endeavours to procure registration of the strata plan by the sunset date. Then it goes on to talk about what happens in the event that registration has not been obtained. I was involved recently in a case where I acted for the purchaser. In that instance, it was our application that the vendor had not done what it needed to do to register the plan. It was a plan of subdivision in that instance. We took the vendor, the subset clause lapsed, vendor sought to rescind the contract. We took the vendor to court. This was actually before the Conveyancing Act legislation had come in, and sought damages on the basis of the vendor had failed to comply with the reasonable endeavours clause. So it is a really important thing to consider at the time of entering into the option agreement and any milestone events which may be included in the option agreement. Then there's an option fee clause. In a falling market where a developer may not proceed to exercise the option, it's really important that you either negotiate out of payment of an option fee. Generally speaking, a purchaser is going to insist on the payment of an option fee, so that may be difficult to do. The other alternative is to try and have an option fee payable by way of instalments, and then trigger when that instalment is payable and then also when it needs to be forfeited in the event that a developer does not exercise the rights under the option agreement. So just here you can see here that we've got that the owner is only to retain the first instalment of the option fee, and the owner must not and is prohibited from pursuing the developer for any claims or other losses, and the rights under the deed will come to an end. Stepping up now to the strata renewal process. So looking at the flowchart again, we're here. The strata renewal process becomes really important, particularly in a falling market. So it's a really topical issue at the minute. It could have been a whole seminar on its own. We've had a few people, though, want to know a little bit more about the strata renewal process, so we didn't want to keep everyone waiting until next year. So sometimes owners may be living in a particularly rundown, dilapidated building. It might be that the strata scheme is considering selling the building if it's really old and it needs repairs. A lot of the owners might wish to sell it as opposed to repair it, sell it to a developer who'll knock it down and put something else there. It might be that the vast majority of residents want to do that, but there are some who just want to stay put, whether they want to fix it themselves or not fix it at all. It causes an issue and conflict within the owners. There's going to be an increase in owners who don't want to sell, called dissenting owners or dissidents. Particularly in this market, they might want to be holding out for $1 million. They're only going to get $700,000 and only less if the market continues to drop. So what happens then when you've got quite a few who do want to sell and others who don't? In that event, the Strata Schemes Development Act allows for owners to now follow a strata collective sale or a redevelopment of their strata scheme. So this process came into effect in November 2016, so it's still relatively new. The process enables the owners in a strata scheme to apply to the Land and Environment Court for an order relating to one of two options, either a collective sale, and that is when all of the owners wish to sell together. There are no dissenting owners, and they may sell to the developer for one price, with that sales price then broken up into, for each of the owners, based on their allotment of units. On the flip side of that, you've got a redevelopment of the strata scheme, and that might involve the sale of each individual units to a developer for different prices, and that is not dependent on their unit entitlement. That is the process that will need to be followed in the event there are dissenting owners, because they're each individual sales. But ultimately, for a strata scheme to be sold or redeveloped under this process, there needs to be at least 75% of owners in the scheme who agree to sell. Secondly, the Land and Environment Court must be satisfied that the whole process has been just and equitable and that the process has been followed accordingly. So the process itself. Step 1, the owners need to opt in to consider the strata renewal process. So they have a meeting and they determine whether or not they should even consider it. There needs to be at least 50% of owners who agree to do that. If there's not 50%, the whole process stops. If there is, they move on to step 2. At that point, a strata renewal proposal is submitted and considered to the owners. Again, more than 50% of the owners are required to agree that the process itself requires further investigation. If they don't, it stops there. Assuming they get their 50%, they move on. At step 3, they establish a strata renewal committee to investigate the process and prepare a plan. At this point, they may engage some consultants to assist, whether that be some tax advice, a lawyer, a valuer to determine the value of the units, an agent. Assuming that so then the Strata Renewal Committee has been formed. Generally speaking, it's not the committee that prepares the plan. Often it's a developer who'll prepare it on behalf of the owners and then put it to the owners for consideration at step 4. So they prepare the strata renewal plan, and that will either be for a collective sale, and that's where the price will be apportioned, or otherwise for a redevelopment of the strata scheme, and that's where the individual units are sold. Step 5 is where a general committee is called to consider the strata plan or strata renewal plan, and at that point is where you need to get at least 75% of the owners agreeing to proceed. If they can't get the 75%, the whole process stops. If they do get 75%, they then make an application at step 6 to the court for orders approving the plan. At this point, the dissenting owners need to be made aware of the application. They're given the opportunity to file an objection if they wish to do so. If there are dissenting owners, the court will order mediation to try and resolve the dispute between the parties and try and determine exactly what the dispute is. The court will then make an order, and that will require that the scheme be sold and that all owners are paid not less than the compensation value. Now, in terms of the compensation value, that is calculated in the same way that a compulsory acquisition process is valued. So there'll be a valuer, and then the factors in section 55 of the Act will be considered in terms of whether or not they ought to get additional payments. But the safety net is considered the safety net that they are required to get not less than the compensation value. Assuming then that they've made it that far, the court will make the order and the sale in step 9 will proceed in accordance with the order. So that's all from me. I know I've rushed through the renewal process quite quickly. If you do want to speak to me afterwards though, I'm open for questions.
Well, thank you, Sharon. Next we have Tony Abboud. In 1980, having completed a BA degree in economics and accounting, Tony commenced his real estate career as a salesperson. He was made a partner of the real estate office in 1982 and became sole owner of the Snowden Parkes Group of companies in 1985 at 27 years of age. Since this time, Tony has continued to build the Snowden Parkes Group into a diverse, highly successful group of companies. Tony has spent the past 36 years building strong and profitable partnerships with developers, both large and small. In doing so, Tony has earned a reputation for generating outstanding results for his clients. Tony's competitive and disciplined approach has further boosted his reputation for success. His driven and professional approach has created outstanding results for his clients. You can trust that Tony will deliver on his promises and his integrity is guaranteed. Tony has spent many years working with the Ryde, Parramatta, Hillshire, Penrith, Fairfield and Hornsby councils. He has also worked directly with various state government departments, both at staff and ministerial level. Please welcome Tony to the lectern.
Thank you. I think firstly we should put things into perspective from a development point of view as to where we are today. In Sydney, from 1999 to 2011, over 12 years, nothing happened in prices. Prices were generally flat for 12 years. And then from 2011 to 2016, Sydney doubled. So in 5 years we doubled after 12 years of flat prices. Then we peaked in 2017. Last year was the peak. And then we all know what started to happen this year. We've started to work our way back. I recall in 2005 you could buy a one-bedroom unit off the plan for $350. In 2010 that one-bedroom unit became $385 to $420. And then in 2016 that one-bedroom unit was somewhere between $650 and $720. So you could see what happened between 1999 to 2017. So now, where are we today? Let's go through some of these things. Booming market. There is one thing that I want to mention that's in between the lines of this slide, and that is if you were a developer, the last thing you thought of was sales, because the sales were assumed. You didn't have to think about, are we going to make the sales? You didn't have to think about the sales rates. The sales were assumed. All you had to do was the generic things, put up a display office, put up a website, do a brochure, create a brand, engage an agent or a series of agents, and the sales happened. And we knew prices were going up, pre-sales were done in a short period of time, there was no issue with sunset clauses, everything was good. You were going to get the amount of pre-sales that you needed to fund the construction, so you got your construction finance. The only issue with the boom of the market was when was the top going to happen? And for 3 years everyone's saying, oh, surely this is it. It can't go any more than this. But guess what? It did. It kept going until now. So then we entered into a different sort of market. The sales rate and the turnovers obviously slowed down. Now, you know what happens in the way the market works. Turnovers slow down, then the prices follow. It's in the same way in the return. The turnovers go up and the prices follow in a booming market. So once the turnovers start slowing down and developers, owners, agents say, hold on, how come this hasn't sold? You know, we used to put it on the market and it'd be sold like that. Now it's taking a week. Now it's taking a month. Now it's taking 120 days. And then what happens then? The prices then follow as the turnovers slow down. So that's one of the things that is a dominant factor of a falling market. The problem with a falling market for a developer, the time from the initial pre-sales to the pre-sales where you now qualify for development finance, the early pre-sales might be out of that time frame for the sunset clauses. And the banks, we've had many situations where the banks have said, okay, you've sold enough to qualify for finance, construction finance, except for the fact that the early pre-sales don't qualify anymore because they're outside of the sunset clause. So they're the sorts of things that start happening in a falling market. One of the biggest things, and this impacts the integrity of a project, is where subsequent buyers pay less than the early buyers. Now that impacts on the integrity of the project, because one of the very first things I was taught when we started doing project marketing in the early 80s, you always made sure that every buyer who bought always paid the same or more than the previous buyer. Because if they paid less, that impacts on the integrity of the project and could also impact on valuations at the end of the period as we come up to settlement. So there's some of the characteristics of the falling market. You've also got to understand something, that Sydney now is so big and so diverse, it's actually made up of 11 different market sectors. At any one point in time, you could have one sector going up and another sector going down. You could have houses doing really well, but you could have apartments going down. Even within a geographic region, you could have different levels, some going up, some going down. You could have different types of properties. The one thing you've got to be aware of in this sort of market is you've got to ignore what the media says, where they say the market's going up 10% or the market's going down 5% or the market's going down 15%, because the market is so diverse now, it's not that simplistic. There is a whole range of variables that impact the market. You've got to take into account geographic areas, you've got to take into account infrastructure, you've got to take into account demographics. It's really complicated. And in one area you could have houses stable, but you could have units coming back 15%. Do you see what I mean? So it's very important how we look at what's happening in the market. So let's look at some of the variables in property development and let's translate them into the marketplace today. As you know, in property development, we've got two types of sites we can buy. We can buy DA approved sites, or we can buy sites that are raw and put them through a DA process or a planning proposal. Let's look at that in the context of today. DA approved sites, the beauty with DA approved sites is that you don't have to deal with councils. You don't have to deal with the politicians. You don't have to deal with staff. Now let me just say, you've also got to sort of be lenient with council staff, because they've got rules that they have to follow. So they can't just sort of sign off on anything that we ask for, because they've got due process that they've got to follow. But be that as it may, you've got to go through that due process. So let's talk about a DA approved site in a market like today. Sites have, DA approved sites are a lot cheaper. How much cheaper? 4,000 a square metre has gone down to 3,000 a square metre. I know one example that's gone down to 2,300 a square metre from 4,000 a square metre as a site. And the developers need to renegotiate even lower than that. I've seen sites that were between 80 and 120 a site. One just sold for 40 a site. So in some cases halved, in some cases more than halved. Now the problem with the DA approved site is that it's gone down in price substantially, in some cases half the price. The good thing is we can start selling it straight away. The problem is it's not selling. So even though we bought a DA approved site, right, it may not be appropriate for us in this market because it may not be saleable. Now we'll talk about the dynamics of that in a moment. The other type of site is the raw site, the planning proposals, the DA approved. Let me tell you, at the moment in the marketplace, there's tier 1 builders, or developers rather, and there's tier 2 and 3 developers. The tier 1 developers, the big corporates, the ones who aren't choked with finance, the ones who aren't sort of holding massive amounts of stock, their strategies today is let's buy these raw sites. Let's put them through a planning proposal, because over the next 2 to 3 years, as we're going through the planning proposal, by that time, as we've got our approvals come through, the market's turned. Now, a lot of the big corporates, that's their strategy. A lot of the second or mid-tier developers are saying we'd love to do that, but we're caught up with too much stock. We don't have the financial ability to snap up these sites. I know some developers have walked away from sites like this for 2 reasons. One, they've had a gutful of the process, and the second reason is the market has changed and the financial modelling doesn't work. But let's talk about site acquisition in terms of these categories here. We've talked about the current sites. They're substantially cheaper, and we've talked about the fact that, whilst building costs are consistent, the 2 variables are the cost of the land and the selling prices at the end. So that's one dimension, the current sites. But we've also got to be very careful, because future sites are going to be difficult to get. And the reason why future sites are going to be difficult to get is because in the last 3 or 4 years, a developer could quite comfortably come and offer a landowner a margin above the retail price. There was enough fat in it. So, for example, if your house is worth 1.8 million, a developer could offer you 2.5 million on an 18-month option, and you're thinking, well, it's not going to be worth 2.5 million in 18 months, so it's a good deal for me. I'll sell it to the developer for 2.5 million. But today, the developer's saying, well, if it's worth 1.8 and that price is actually coming down a little bit, I may not even be able to offer you more than 1.8. So, and then the owner says, well, if you can't offer me more than 1.8, if I can get 1.8 for it at retail today, why should I tie it up for 18 months at 1.8? So future sites can potentially get difficult to acquire. I've had sites where we did an assessment at one period and they were worth more as a standalone property than as a development site. Then 2 years later you reassess it and now they're worth more as a development site than a standalone. So you need to be aware of those dynamics. There's a greater gap, I mentioned this before, there's a greater gap between tier 1 sites and secondary sites. One developer said to me, you know why I won't buy this site? And I said, why? He said, it's just another block of units. And that to me was very insightful, because in a marketplace in the way we're moving now, you need some sorts of points of difference. You need something that differentiates your product. Because if it's just another block of units, right, there's no reason for someone to buy it. I'll give you an example. If you bought a building like this, a tower of apartments, if you bought an apartment on level 37 or you bought an apartment on level 25, the view corridors are identical, everything is identical, what's the point of difference? It's no different than buying an appliance. Now, the market we're moving into, the points of difference are going to be critical. And the tier 1, like even in this market where there's all doom and gloom in the media, the good sites, the landmark properties are selling. They're not impacted by this sort of market. But all the second tier properties and third tier properties are now, unfortunately, to the marketplace, just another block of units. And you've got to be very conscious when we're looking at sites and we're looking at a whole range of things, which we'll talk about in a moment. Is this a tier 1 site? Is this a landmark site? Or is this a second or third tier property? Very, very important. Now, the product now becomes a lot more important when we're talking about product. It's no longer about maximum density. It's no longer, and I can talk about this because of my Lebanese heritage. Lebanese developers, they get a site, you can put 50 on the site, they do 120. Because, that's the way you do it. That's the way the Lebs do it. We can't do that anymore. Now you can do 50, we'll still go for 80. But now it's all about, we've got to focus on the number of apartments, we've got to focus on the mix between 1, 2 and 3 bedroom, we've got to focus on the size, we've got to focus on the type of product. It's all about a building to the market. And this is very, very important in this day and age, because you've got to build, what's that phrase, begin with the end in mind? We've got to focus on building the product for the market. So you've got to think of things holistically. It's now all about the business model. It's not just about a single dimension of looking at the site as a standalone. Now, the other thing from that point of view is we've got to consider things in terms of a competition matrix. Whenever you're assessing a site in this day and age, you've got to be looking at the site in terms of the number of projects you're competing with. You've got to be talking about number of apartments, not just number of projects, but number of actual apartments that you're competing with. You've got to be matching size, finishes. You've got to be looking at the current sales rate. You've got to be looking at current price points. You've got to be looking at projects that are due to be launched, that are currently that haven't been launched yet, but are due to be launched as competition. You've got to be looking at projects that are in the planning process. You've also got to be looking at projects because in the last 6 months, for the very first time in 5 years, where you're seeing now projects and apartments that are complete that are unsold. Now, in the last 5 years, you could rarely walk into an apartment that was complete, that you could walk in, touch, feel and whatever, but it was unsold. All of a sudden, that dynamic has changed. So now there are many, many apartments. There was one developer who spoke to me 2 months ago or 6 weeks ago. He said to me, Tony, I've just settled 90 apartments. I said, that's good. He goes, not really. I said, why? He said, every one of my overseas purchases defaulted. He said, I've now got 30 for sale that are complete. Now, that dynamic hasn't happened before. Well, it certainly hasn't happened in the last 5 years. So when you look at a competition matrix, you're now looking at your site, you're looking at a development from a holistic point of view rather than as a development as a standalone. And that's very, very important in terms of strategy. And in terms of strategy, I'll give you an example. There was a site, you could build 340 units on this site. Did the business modelling, the modelling worked beautiful. It worked beautiful, but there was a couple of problems. The first problem was it was unlikely that council was going to approve 340 units. It was going to be a fight. It was going to be a fight. So that was the first problem. The second problem was that when we did the competition matrix, we said, well, hold on, we're competing against 2,500 units. So why would you build another 340 units and then realise the council was going to give you a hard time anyway? So then we did some sort of market analysis and said, well, what would work? What would happen if we worked on 114 townhouses? We did the market analysis and said, well, there's a massive need for townhouses in this district. Then we went to council and said, would you entertain townhouses? They said, absolutely, right? To the point where they actually gave a letter. Then we sat down and did the business modelling. And it worked out that there was more profit in 114 townhouses than there was in 340 apartments. And it was easier to get through council. The timeline was a lot quicker, and the saleability, the market saleability was much higher. So they're the sort of things that in the old days, call it the old days, you didn't have to do. But now you have to do that sort of stuff. Now let's look at buyer profiling. Did you know that there are 8 buyer profiles? 8? Sorry, I'm actually nervous because I've never had this many lawyers stare at me before. This is amazing. There's 8 buyer profiles who buy apartments. There are 8 buyer profiles who buy apartments. And if you benchmark any apartment across Australia, they meet these 8 buyer profiles. Now, I didn't bring them with me, but anyone who wants them, I'm happy to share them with you. So in this day and age, you've got to be looking at buyer profiles. Who's buying it? Where can you find these buyers? And what's the propensity of demand? Let me tell you today, if you're selling a project, forget about the old-fashioned appoint an agent, get a display, get brochures, set up some collateral, and do a display office. That's not how you sell projects today. I'll tell you how you sell projects today. You sit down and you say, how can we arrange finance for the end user? That's how you sell projects today, because today it's about financing. It's not about finding a buyer, because if all of a sudden there was thousands and thousands of buyers and there were queues of buyers, and then all of the buyers disappeared, did they all buy? They didn't all buy. I'll tell you what happened to those buyers. They did this. They pressed pause. And they pressed pause for a whole range of reasons. One of the reasons might be, things are not sure about the way things are going. Maybe we should wait and see. Politics, which I'll talk about in a moment. But more importantly, finance. So in this day and age, if you can show that there's finance available for your product, then you've got a higher propensity to sell, because people know that if I can get finance, because in the traditional business model in real estate, when interest rates were high, real estate was down. But now interest rates are as low as they've been in 25 years. So why is real estate down? I'll tell you why real estate's down, because today it's not about a price problem, which is interest rates, it's about a supply problem. It's a money supply thing. So if you can solve the money supply for the end user, then you've got a higher propensity to sell your product than just putting out a display office. I remember one agent was opening a site from 11 till 4, 7 days a week for 2 years. And a busy week was when 3 people walked in to his display office, and one was walking the dog. And that was a busy week, right? Now, you've got to think differently, otherwise you're not going to, and you've got to focus on the buyer. Now, the other thing we've got to talk about is politics. Never has politics been as relevant in the marketplace as it is today. Now, there's a couple of things that we need to talk about politics when it comes to development. There's the interaction and the relationship between local council and state government. And as you know, in the last 3 or 4 years, state governments have been very, very active in the development space and interacting with councils. There are a lot of councils that don't like state government, a lot of state government people don't like various councils, and it's a fight. And if you're caught in the middle with a site, right, you need to know how you're going to sort of play so that you can get your approvals. As we know at the moment, because of political pressure, there are 50 councils in New South Wales at the moment where you actually can't put in a planning proposal. And the reason you can't put in a planning proposal is because the agreement is that they've got to redo their LEPs. Now that's a good thing and a bad thing. The good thing is you can still go through the process of getting your site approved, but instead of through the planning proposal, through an LEP process. Now, the good thing about that is, I know, for example, one council, the fee to submit a planning proposal is $210,000. One is $153,000. I said to the guide council, what do you get for $153,000? He said, you get a number. I said, so that's all you get? He goes, yep, that's a submission fee. Now, if you go through the LEP process, you don't have to pay those sorts of fees. For the very first time, I can tell you quite definitively, there'll be a different set of planning rules and a different set of attitudes to planning and planning proposals and approvals before and after the state election on March 23rd. Because at the moment, there's too much politics going, and both parties, both sides, are on this anti-overdevelopment platform. And I've said to both sides of politics, you're both saying the same things, you just do in different words. You're saying it using different words. And unfortunately, that impacts on people who are trying to make financial decisions, strategic decisions. So politics is very, very critical at the moment. There's also a difference of what happens in federal politics somewhere between now and May of next year. We know that there's going to be major impacts in the development industry if negative gearing is impacted and if capital gains tax is impacted. And that strategically impacts your decision. One thing that I was told was over the last 25 years, it doesn't matter who came into power, it really didn't matter because they were all the same. But what we've been told now is for the very first time, the policies are actually opposing each other. So for the very first time, it is actually strategic as to who comes into power and when they come into power as to in terms of your decision, should I go this way in terms of my development or should I go that way? And it's very, very important. And I'll give you some examples. Of how politics comes into play. One developer hired top-notch architects, top-notch planners, and put in a submission through council and state government for a 27-storey tower. The only problem was they didn't engage with the politicians, and they got the council offside, the politicians, the councillors. They got the council staff offside. They got the local state member offside, and they got the Progress Association offside, which is quite militant. And that's because they focused on process rather than trying to merge the two. And because they focused on the process and rather than interact with the politicians at all levels and the staff, because you've got to respect the council staff, right, they're now in trouble because this particular council's going through the LEP. If they don't get it through with this under the current LEP process and the LEP is ratified without this 27-storey tower being approved, they've now got to wait another 5 years before they can start again. And that's because they focused on process and ignored the people who make the decisions, both the staff of councils, the local member, the state member, and the Progress Association. I had another situation where developer engaged with a politician, did a deal with a politician, they agreed on something, right? When it got to council staff got upset that the politician had done the deal with the developer and didn't include them. So what did the council staff do? They slowed everything right down, right? So, and it was their right to do that because they were dotting the I's and crossing the T's. It was their right to do that. So because the developer jumped the gun, went straight to the politician, they put the council staff offside. You can't do that. There's a very fine line between balancing the two and respecting both sides. So it's a combination of politics and process, and that's very, very important in this day and age. Now, I think I've run out of time, so I think I'll leave it there. Thank you.
A lot of content, but does anyone have any questions on either what Tony or I had to say? Everyone just wants to get out and have a drink.
I think so.
David.
Thank you. So Sharon, it's going back to strata renewals. If you're an owner and you think it's a good idea to go and sell to the developer as part of your 75%, but then you have a change of heart and you think, no, I don't want to do that, does that matter? Can you change your mind? What happens if you change your mind?
So once the owners reach their 75% to agree to go ahead with the strata renewal plan, it's actually lodged on title of the common property that there has been a strata renewal plan agreed to, and then they're stuck with that. So once they do that, they can actually they can change their mind up until the point where it is lodged on title. But once it's lodged on title, it stays there, which then means they then follow on with making that application to the Land and Environment Court. If in the interim at any point they decide, for example, that they want to sell the property, the new purchaser, the incoming purchaser, is actually bound by their agreement to participate with the strata renewal plan. So an owner would be wise to consider the process before they launch into it, and then change their mind quickly before it gets registered on title.
One thing we're finding, and we've seen this on 3 or 4 sites, the developers are buying 1 or 2 apartments at retail by stealth in the building. After they bought 1 or 2, in one case I saw 6 being bought by stealth. Then they make an approach to the balance, and that's the strategy that's being used. It's a good strategy from a developer's point of view. It really irritates the rest of the owners, but the owners who get the offer are now going to get a lot more than from the developers than the ones they bought previously individually.
Tony, as the market declining, I heard about some developers, they apply a strategy like develop and hold to lease out. So what's your opinion about this?
Look, there's obviously tax implications between developing and holding. The first thing is the capacity to be able to hold. Some developers have the capacity to hold, other developers don't have the capacity to hold. The other dynamic is that traditionally when the sales market is down, the rental market is up. This is one of those areas where the rental market is coming down in line with the sales market as well. Although today they reported there's been a bit of a bounce back in the rental market. The problem is sometimes, depending on where the building is and where the project is, if there's an influx of apartments on the market for rent and you're not able to sell, unfortunately you end up in a stuck phase where you can't sell them and you can't rent them. You know, like we just saw one where purchaser paid $950 for an apartment, and the best rent they could achieve was $650 in today's market. So technically that's not a very good return.
Yeah, my question relates to rebates. And Tony made a good point about the importance when selling off the plan to ensure that prices don't decline significantly to new buyers. What's the latest legislation about substantial rebates when selling off the plan? I thought there was some restriction. I know it's a bane for valuers when doing valuations to check sale prices, but wasn't there some legislation to change this last year?
I'm not sure about the legislation, but I'll get Sharon or one of the team here to talk about that. But I'll tell you what's happening in the marketplace. I had one quite substantial developer come up to me and say, look, there's 10% you've got to play with on selling these completed apartments, not the off the plan, the completed. And the attitude was, you've got 10% to play with. If you do a deal and say your fee's 2%, well then the other 8% we will rebate it back to the buyer on settlement. And the buyer can say, well, we'll give them a cheque straight back to the buyer, or we'll give the cheque to whoever the buyer nominates. It could be their financier or something. So they're giving the agent, say, a percentage to deal with. Now, obviously, they want to keep the price high for valuation purposes. Now, I don't know the ethics of that. I don't know the legality of that, but that's what's happening in the marketplace at the moment. They're offering rebates that are payable on settlement, and that's a strategy to sell the apartments. Now, if the agent pulls 4% and only rebates the buyer 6%, that's up to the agent and the buyer. But I don't know what the ethics are involved in that, because there's an element of we want to keep the price points high so that the valuations are high.
I'm not aware of any changes to the legislation recently with respect to rebates. I certainly know, and Tony and I have had this discussion previously about developers doing that and certainly trying to, I guess, hide it from the banks that there's an issue with the valuation, but it is one way to enable the sale to proceed so that the purchaser ultimately doesn't have an issue with gaining their finance.
It's important to also protect the purchasers. By keeping the price at that point, you're also protecting the purchasers in the sense that most purchasers are buying and they're retaining for 5 to 10 years. You know, there's an article being written, there's a good time to buy off the plan, there's a bad time to buy off the plan. Today is not a good time to buy off the plan if you're a speculator where you want to on-sell. But it's always a good time to buy off the plan if you want to buy it to hold it. If you're an investor and you want to hold it, if you're an owner-occupier and you want to hold it, the price points are good at the moment to buy off the plan. But this is not the time frame to buy off the plan and on-sell. You know, there was a period there where people were buying off the plan an apartment for $595, and by the time the project had finished over the last 5 years, they were on-selling at $850. Unfortunately, in this marketplace, that's not happening. If you bought a $950 apartment off the plan today, by the time the project's complete, you're probably selling it for the same price or maybe a fraction less. We've seen $5,000, $10,000, $20,000, $30,000 off the initial price, the off the plan price.
Could I ask Tony and Sharon, I happen to invest in factory unit complexes. Are they paralleling residential property or do you think there'll be a delay and then they'll parallel them?
My experience with factory units, it's more about the economy. The factory units are invariably being sold either to people who are owner-occupiers, small businesses, or they're being bought by investors who are going to sort of lease them out to small businesses. And it's all about the propensity of business. When you're selling factory units or when you're leasing factory units and you're preparing a lease, it's all about the business model for the tenant. If you've got a business that is very strong, then you're potentially going to buy the factory unit for yourself. If you're buying a factory unit today that has a tenant in it and the market's not that strong, the first thing you do is, before you look at the product, you look at the business of the tenant. If that business is very strong, they've got a good business model, then you know your rent is protected. And then you look at the lease. If it's a good lease, so if they've got a good business, they've got a good lease, then you're safe to buy that factory unit because it's all about the business and the business model of the operator within that factory unit. So I always think about the factory units, the commercial, the retail. That's more about the general economy. That's about full employment. That's about infrastructure. That's about, you know, what's happening out there in terms of money supply, rather than the single dimensional of residential, which is supply and demand.
Now the questions. All right. Thank you everyone for coming. Thank you, Tony, for presenting
Sharon.
with me today. I've got here a bottle of wine here for you.
Oh, thank you.
Thank you.
Thank you.
Thanks everyone for coming.